Your mic is closed.
Okay, the Appellate Division First Department is now in session. Welcome all to our virtual session of oral argument. I'm about to call the calendar. I would ask you to please listen for the name of your case as well as the time that we have allotted to you for oral argument. People versus Clark Bell. The appellant is allotted 8 and 2 minutes. The respondent has 8 minutes. Velocity versus Stop and Shop is submitted. Tawanda versus Joseph A. is submitted. City Mortgage versus Moran. The appellant is allotted 5 minutes for argument. The respondent is submitted. Rivas versus Nestle Realty. The appellant is allotted 5 minutes. The respondent is allotted 5 minutes. People versus Gilliard is submitted. Anderson versus Nietzsche is submitted. Gutierrez versus Mount Sinai, it's 2 cases. They are both submitted. People versus Leonide is submitted. Steele versus Nietzsche, the appellant is afforded 5 and 2 for rebuttal. The plaintiff respondent is allotted 5 minutes for argument, and Nietzsche is allotted 3 minutes. Williams versus City of New York, the appellant is allotted 6 and 2. The respondent is allotted 6. Gross v. Aronson Mayovsky is submitted. Live Nation versus Greenwich Insurance is allotted 7 minutes and 2 for rebuttal for the appellant, 7 minutes for the respondent. Hudson Yards is submitted. Ammon versus Johan is submitted. Ixis Real Estate versus Natixis Real Estate, 5 and 2 for the appellant, 5 for the respondent. LB versus Stahl is submitted, and Board of Directors versus Platt is submitted. The first argument is People versus Bell. The attorneys step up or virtually step up.
Thank you, Your Honor. This is Attorney Lily Kim for Appellant Clark Bell.
You may proceed.
Yeah, thank you, Your Honor. I may please the court. I'll first address our argument regarding the criminal possession charge that the people failed to prove that Mr. Bell knew that the tickets were forged. Then I'll address our argument regarding resisting arrest charge that people failed to prove Mr. Bell affirmatively engaged in some conduct to resist arrest. Lastly, I'll argue that his sentence of 3 to 6 years is unduly harsh and excessive for a non-violent crime. Possession charge. Yes, Your Honor.
You froze, but you unfroze. So you can proceed.
Sorry. Is that better?
Believe me, I don't think you had anything to do with it. Go ahead.
Thank you. Regarding the criminal possession charge, there are 3 reasons to doubt people's evidence of Mr. Bell's knowledge. First, while Mr. Bell asked Officer Doherty inside the deli if she were a police officer, he was concerned about selling legitimate tickets in the vicinity of Madison Square Garden, and rightfully so because New York prohibits ticket speculation even if they're legitimate tickets. Second, in pointing to the fact that Mr. Bell pulled the tickets from one of the flower pots, people assumed without any evidence that he himself had made the tickets and put the tickets in the flower pot. Instead, equally strong.
May I ask you a question?
Yes, Your Honor.
My understanding is that the officer who went to the deli or met him at the deli, that when she was with him, he took the tickets out of the envelope and physically saw the tickets. It was her testimony that you could tell by looking at these tickets that they were forged. Why doesn't that satisfy weight of the evidence?
Well, Your Honor, the officer who testified the tickets were counterfeit, she was an experienced and trained officer who has tried numerous cases involving counterfeit tickets, but Mr. Bell, as a layperson, could not have said that these tickets were counterfeit. In fact, at trial, do you have any question, Your Honor?
I'm listening.
If not, I'll proceed. So at trial, the people relied on expert testimony to show that the tickets were counterfeit, relying on the expert's extensive experience and witness. And the expert also confirmed that he used all resources available to him, including the event code scanner. To determine.
This is Justice Weber. The expertise or the expert witness presented at trial was in order for the people to sustain their burden to show that the tickets were in fact counterfeit. The question posed by my colleague Justice Gish was the fact that the tickets were obviously of poor quality, that the printing was blurred, the material of the paper was sticky apparently. So even a lay person would have known that these tickets were counterfeit, and it was not necessary for an expert to make that determination. You talked about the officer at the deli. The testimony was that they were obviously counterfeit. If you just touched them, if you just looked at the printing, the blurredness, that he would have known.
Your Honor, at the trial, the expert actually testified that the touching of the paper itself wasn't enough. Then he actually used all the resources available to him to confirm that the ticket was counterfeit. Unfortunately, we haven't had a chance to examine the tickets themselves. However, the fact that the people relied on expert testimony shows that the quality of the ticket wasn't, in fact, so poor as to put a layperson on notice. Moving on to the next argument regarding the resisting arrest charge, people failed to prove that Mr. Bell acted in any way to resist arrest. The case law is clear that the defendant has to affirmatively engage in some conduct, and inaction does not constitute resistance. And the video footage shows that Mr. Bell did not make any physical motion to resist the officers.
I thought he tried to run.
No,
I thought that the testimony was that he started as they were waiting for transport to the precinct, which would be part of the arrest process, right? And constituted the resisting arrest. That he became agitated, he began to scream, and he tried to run.
Your Honor, that's what the officers testified, but at that point, Mr. Bell was already under arrest. And in fact, in People versus Hasenflu, one court refused to consider the defendant's post-arrest conduct as an evidence of resisting arrest. In fact, in all the cases that people cited where the defendant attempted to run away, they did so before they were arrested.
But even when they asked him to put his hands behind his back, he started screaming that they were breaking his arm. They told him to comply. He refused. I mean, so it was more than just his, I'm sorry, he did attempt to prevent the arrest by, again, moving his arms, not complying with their command, yelling and screaming. That all constituted resisting arrest, did it not?
So, Your Honor, the testimony that Mr. Bell was flailing his arms was based on the officer Christopher and Officer Doherty's testimony, but they later retracted the testimony and only argued that he was keeping his arms rigid. And every single case law that people cited involved something further, a further physical movement, not necessarily using force, but nevertheless something more than tightening the muscle. Mr. Bell, on the contrary, did not grab the officers or try to push back against them or flailed his arm or fled away. So even if his convictions stand, his sentence of 3 to 6 years is unduly harsh and excessive, and we submit that this court should reduce it to 2 to 4 years following this court's decision in People versus Mitchell, considering the non-violent nature of the crime and also Mr. Bell's life circumstances at the time.
He's a predicate. Was he not a predicate?
Yes, he did have 2 predicate felonies, and we request 2 to 4 years, already taking into account his predicate felonies. So not only is this crime inherently nonviolent, Mr. Bell did not use any violence throughout the attempted sale of the ticket or during his arrest. At most, he stiffened his arms. And further, his life circumstances provide a context for the crime and also a compelling basis for reducing the sentence. He was homeless and unemployed at the time. He was also going through a substance abuse program and suffered from poor physical health due to high blood pressure, requiring his treatment and medication. And when faced with similar factors, this court in People versus Mitchell reduced the sentence for criminal possession of forged instrument. Lastly, Mr. Bell's criminal background does not preclude a sentencing reduction. In Mitchell, the court reduced the sentencing, notwithstanding.
You mean the 4 prior felonies and the 29 prior misdemeanor convictions were all in line with, again, they should not be taken into consideration given the fact that the defendant received just a little bit more than the minimum?
Not that it should not be taken into account, even though the court can definitely take them into account. In Mitchell, notwithstanding the defendant's extensive criminal history involving 5 felonies and 25 misdemeanors, including many violent crimes such as attempted rape and attempted robbery, the court still reduced the sentencing in the interest of justice. And under these circumstances, sentence of 2 to 4 years is an ample punishment for selling counterfeit tickets. And for these reasons, we ask the court to reverse the convictions or, in the alternative, reduce his sentence to 2 to 4 years. Thank you.
Thank you. Thank you.
Good afternoon. Yes, thank you, Your Honors. Good afternoon, Your Honors. Jonathan Cantarero for the People. Just to start with my adversary's first point regarding the counterfeit tickets, the point that appellate counsel hasn't had the opportunity to review them. The point is that the jury did have the opportunity to review them at trial, and that's precisely why, as Justice Weber pointed out, we had the expert witness testify to the various features that were confirmed by the undercover officer that established that any lay person would be able to tell that these were fake tickets. And it's not just the blurriness of the text, the stickiness of the material, and the factors that the officer and the expert testified to. It was also defendant's behavior in attempting to complete the transaction. A reasonable person wouldn't leave over $1,000 worth of tickets in a flower pot in the middle of Manhattan unless they really had no value. And so there's just simply no basis to reject the jury's conclusion that defendant was clearly aware that the tickets were counterfeit. In fact, regarding the concern of the police officer's vast experience in identifying counterfeit tickets, if the officer had made the arrest without having that experience, we would be here and the defense counsel would be arguing that there was an insufficient basis of knowledge to establish probable cause and effectuate the arrest.
Well, that doesn't affect her argument that's being made here, that the officer did in fact have experience with counterfeit tickets, and that was the basis for her being able to identify them. And I'm not sure that there was a predicate, an evidentiary predicate, for her to be able to testify that a layperson could identify them as counterfeit. What's the basis for her testimony?
Well, to be sure, Your Honor, trial counsel below never objected to the police officer's testimony regarding having a sufficient basis to make that determination, never challenged the expert witness's testimony to provide their opinions on that regard. So to the extent we could cobble up that type of argument from the defense briefs, I would argue that they're completely unpreserved for appellate review. But again, it's obvious from the testimony, the blurriness of the text, that she immediately recognized them to be counterfeit based on all the factors that were mentioned, in addition to defendant's behavior. And it's actually a very interesting point that we mentioned in our brief, and it's mentioned in the reply brief, the distinction between the facts in this case and People v. Johnson, which this court decided earlier this year. The facts couldn't be more different. In that case, the defendant had momentary possession of an envelope which contained, it was eventually determined, counterfeit tickets.
The big difference there is that there was no evidence that the defendant actually physically saw the tickets. It's a big difference, isn't that?
Absolutely right. And in this case, not only did the defendant have to look at the tickets, but we know he had to look at the tickets for a significant amount of time, not only to distinguish between the Knicks and the Rangers tickets to select two as opposed to another number, but he also was right in front of the undercover officer as she examined the tickets and determined that they were also illegitimate. And just to my adversary's second point regarding the resisting arrest charge, this court is obviously in possession of the surveillance footage. The officers had handcuffed defendant's left arm, and then two officers were attempting to pry his arm back. The point is that the counterforce defendant had to exert in order to prevent the officers from completing the arrest and linking his hands together is in effect a resisting arrest. But of course it didn't stop there. The struggle eventually went to the ground, and then you had a third officer who was the original undercover officer see that the officers were struggling, and then there's actually one point in the surveillance footage where all three officers have their hands on defendant's right arm trying to pry it back. Now, this entire sequence of events took between 90 seconds to 2 minutes, which, as your honors are well aware, is an extremely long period of time to complete an arrest. So the only reasonable explanation for that conduct, that behavior, that series of events is the defendant was resisting arrest until the bitter end. And as Justice Weber pointed out as well, obviously the conduct continued when he attempted to run away from the officers, threatening to kill another officer. All of that goes to his consciousness of guilt. And just to the last point regarding the excessive sentence point, this is not the case to argue for a reduction in a sentence. Defendant was convicted of the same exact crime and received the same exact sentence only a couple of years ago. He was on parole from that conviction when he committed the instant crime. He has since committed 3 additional offenses, and my office recently learned he was arrested as recently as October 1st for grand larceny. He has clearly demonstrated, based on his extensive criminal history leading up to the instant offense and his subsequent actions, that that there is no basis for reducing his sentence. I know my adversary cites drug abuse and potential rehabilitation, but it's important to note, as the sentencing court was aware, that he was on a day pass from his drug rehabilitation program when he committed the instant offense. So for all those reasons, we respectfully request that you decline the invitation for a reduction of the sentence and that you affirm the conviction. Thank you.
Thank you. Rebuttal, counsel?
Yes, Your Honor. I only have a couple points for rebuttal. Regarding the excessive sentence argument, while the sentencing judge below did hear all the factors from the defense counsel, the ultimate sentence of 3 to 6 years did not deviate much from the prosecutor's recommendation of 3.5 to 7 years. And the fact of the matter is, he was arrested recently, and there are usually no miraculous turnarounds, and the person may continue to be involved in the criminal justice system in the low-level ways.
Well, but we certainly would not consider any new arrests. We would only be considering the record, and the record before us would be his convictions leading up to this particular incident. But your adversary's point is well taken. If he had, in fact, a prior incident where he received the same sentence, and also if he was on parole for the same type of behavior, then that again would go to the fact that this was not an excessive sentence and perhaps it was warranted under the circumstances.
Well, Your Honor, I asked the court to consider the nonviolent nature of the crime as well as the life circumstances that he was facing. And a maximum of 6 years for this kind of crime is still excessive and trigger a long period of incarceration for technical parole violations that does not help him focusing on becoming a productive member of the society. Thank you, Your Honor.
Thank you. Thank you both. The next case is City Mortgage versus Moran.
Good afternoon, Your Honor.
Good
My name is
afternoon.
Gordon Smith, representing the plaintiff appellant here, City Mortgage. Can you hear me, Judge?
We can hear you. Can't see you. Can my colleagues see Mr. Moran? Okay, you can proceed.
Can you see me now, Judge?
No, but I can hear you.
Okay, well, that's probably the most important thing.
Yeah, now I can see you. Go ahead.
Thank you. So in this case, the Supreme Court erred in its application of CPLR 205A. The prior action was dismissed by this court, the prior foreclosure in 2018, solely on the basis of noncompliance with a condition precedent. And the law is well established that the dismissal for failure to comply with a condition precedent is not on the merits for CPLR 205A purposes. And so in this
in other
case,
words, in this action, you served the 1304 notice. I don't want to say again because you didn't prove in the first one that you served it. So in this case, you served it, correct?
correct. That was not even contested at summary judgment. Compliance with 1304 was not one of the issues raised. They only argued statute of limitations and sort of a pro forma standing point.
So the issue on the statute of limitations to get the benefit of the extension is whether the prior dismissal was or was not on the merits.
Yeah, right. There's 4 ways that you can be outside of the protection of 205A. The only one that's really argued in this case is that it was on the merits. Obviously, there's no question the prior action was timely, for example, wasn't dismissed for lack of personal jurisdiction. So it doesn't fit the other specific carve-outs of 205A. But the law, as I said, is very clear, and there was nothing cited against our argument that found a case that said a condition precedent, in particular anything involving 1304 was some kind of was on the merits for 205A purposes. And it's not an element of the cause of action. You can prevail without proving compliance with that. For example, if you win on default, it's been held that you can't raise it as an affirmative, as a potentially meritorious defense in a 50-15 motion, for example. It's waived. So it's a defense that a defendant can raise, but it's not one of the elements like the note, the mortgage, and the default. And based on that, there's no dispute that this case is refiled within the 6 months and served within the 6 months, as it has to be to get the protection of 205A. And the case was clearly not dismissed for failure to prosecute, although there's lengthy discussion in the narrative opinion from the Supreme Court from Justice Bluth, but it's simply not relevant to go back because whatever delays there were in the prior foreclosure were not the basis for the dismissal. It wasn't dismissal sought on that basis, and it wasn't granted on that basis. It was only for condition precedent noncompliance. So we think it's a very straightforward case of the application of CPLR 205A.
Do my colleagues have any questions? Okay, thank you, Counselor.
Thank you very much.
Okay, the next case is Rivas against Nestle Realty. Step up, please.
Yes, Your Honor. John McLaughlin.
So funny to say step up, but it's a habit, right? All right. Step up to the camera.
Okay.
All right.
John McLaughlin for defendant appellant Nestle Realty and La Dominicana Linen. Please the court, the lower court, is opposition. The lower court erred in granting plaintiff summary judgment as to labor law 241 against the defendants who were the owner and the tenant of a property that was having renovations because there are questions of fact as to whether the staircase that plaintiff fell on due to something giving way per his testimony was a permanent staircase, and it was his sole means of accessing his work area.
I don't understand the permanency argument. I do understand your argument as to the sole access to the work area, but I'm not clear as to the permanency argument.
Well, there is really no question that it was a permanent staircase. There's some question as to whether when it was built, but there's no question it is a permanent staircase or is being built to be a permanent staircase. As of the depositions in 2018, it was.
So when you say permanency, you mean that it was constructed, when it was constructed so that it would be a permanent staircase. Is that what you're saying? But
Yeah.
you don't, because the testimony from the plaintiff was that it was recently constructed, that it had only been constructed like a couple of days or maybe prior to the incident.
Well, whether it was constructed a couple of days before or months before or years before, it's still a permanent staircase.
Well, there was also testimony from the plaintiff that the construction, that it was unfinished, that there were no rails, that there was no whatever you call it, underpinning supports. There were no supports under each step. And as I said, there was no railing.
Yes, Your Honor, that was his testimony. And despite that, he used the staircase anyway, despite previously accessing his work area via a ladder. And that's
was there any testimony that an appropriate ladder was available on the date of the accident? An appropriately sized ladder?
No, Your Honor, there was no testimony specifying that. And our position is that plaintiff failed to meet his burden as to what happened to the ladders that he used to access his work area before with no problem.
Well, the plaintiff testifies that he couldn't access it using that ladder, the ladder that had been given to him days before or weeks before, and that this new staircase was unfinished, and it was unfinished, but it was now constructed. How do you rebut plaintiff's testimony? What is the evidence there for rebutting his testimony as to the lack of an adequate ladder, adequate device, as well as the facts as to this staircase?
Well, there had been adequate ladders that he did get up to his work area via the ladders before this accident occurred.
No, but could that really raise an issue of fact that a month ago there was a ladder on the job site? Could that be enough?
I don't think so. I don't think
it's your burden, right? So what did you put in about the day of the accident and safety, the ladder, for example, is something you're saying in the past. What did you put in to show that there was a ladder that day? He's got no burden. He's met his burden. Now it's your turn.
Well, the burden would include showing that there was no alternate means of accessing the work area, and he had within days before used the ladder.
He testifies to that. So now tell me how you're raising the issue of fact. He testified, this is how I had to get up on that day, and I did it. So what have you put in, assuming that testimony was there, which I think I read, I know I read, what have you got to come up, what have you put in to raise an issue of fact?
What I put in is the testimony that he used the ladder before, and there's nothing that indicates the ladder was taken away. There's nothing.
I want to move to the issue of sole proximate cause. Is there any evidence in the record that he was ever told not to use the stairs?
No.
No. And in fact, he actually testified that the carpenters told him he should use the stairs.
Well, that was his testimony. I believe that would be, hearsay what the carpenters told him, since they're not a party to the case. But
so did you present any evidence saying that he was never told not to use the stairs, or that he was told to use a ladder and not to use the stairs?
I don't believe there's any testimony that he was told to use the ladder or the stairs.
The carpenters told him to use the stairs. So did you put in anything saying that he was specifically told not to use the stairs, or that he was told to use the ladder?
No, Your Honor, his testimony to the carpenters was that he raised concerns about the condition of the staircase to the carpenters, and they told him, don't worry about it. I don't believe that he testified that they told him to use the stairs, but that would still be hearsay what the carpenters told him.
But he wasn't specifically told not to use the stairs by anybody in authority, whether it's his employer or anybody else at the site.
There's nothing in the record I'm aware of that of somebody telling him not to use the stairs. It would just be
counsel, this is Judge Gonzalez, and he wasn't told at any point in time, those are unfinished stairs, they're dangerous, stay away from them.
Well, he was aware that they were unfinished stairs by his own testimony, but I'm not aware of anybody telling him don't use the stairs because they're unfinished. He was aware of that himself that they were unfinished.
Right. Any further questions by my colleagues? All right, we'll hear from opposing counsel now. Thank you.
Good afternoon. Good afternoon. May it please the court. Just to follow up on the issues raised by your honors. So first of all, it's clearly a temporary stairwell. It was made specifically for the purpose of this project in order to replace a scaffold. You can
But
see.
we were talking about a structure that was like an elevated deck, right? It was like a storage deck.
Correct. It's a second level deck.
Well, it wasn't an actual floor. It was an elevated platform or deck of some sort.
Correct. It's about 10
Correct?
to 12 feet wide. Yes.
And was it a structure that would have required permanent stairs in order to make use of it?
There is there's conflicting testimony about whether or not the staircase was meant to be permanent, but that's not really the question that would be before the court anyway. The whole question really is about foreseeability. The only reason to treat permanent stairs differently is because the whole theory is that it would be less foreseeable for there to be an accident from them. In this case, we have a very foreseeable accident for two reasons. First of all, there's no handrail, and foreseeability doesn't require that you foresee the exact way the accident happens. So clearly there is a foreseeability issue of someone having an accident from a stairwell without a handrail. And second of all, as we know, it's unfinished and there's no supports on the top steps. You can see the pictures on page 174 versus the completed stairs on the record, page 320. There's no support under that bottom step, which is actually how it falls. But defendants are the ones who rely on the Vasquez case, and that makes clear on Vasquez that you don't need to have the specific means of the accident being foreseeable, just the fact that the plaintiff is at risk from the stairwell, which we have here. And then even if it was considered a permanent stairwell, it doesn't matter here because it's clear that it's the sole means of access. Under the Cherry case, it's clearly defendant's burden to prove that there was an alternative means of accessing the work site. And just by, as your honors were pointing out, just by showing that there was a ladder there at some vague time before the accident does not put before the court that it was available to the plaintiff on the date of the accident. And also, it's pretty clear that the ladder was not an adequate safety device anyway, but that would be their burden to show that it was under the Knorr case, under the Ramirez case that Judge Suarez relied on in the underlying decision. It's kind of ludicrous to require the plaintiff to use what really common sense would tell us is a less safe means of access in order to get the protections of the labor law under Section 240. That's under Knorr and Ramirez. And there's no testimony other than the plaintiff who says that it was too short for the purpose. And you have both Mr. Martinez, the independent witness who submitted the affidavit, as well as the plaintiff testifying that it was incomplete. And the testimony is really that the ladder was built specifically for this project. Alex said that he was building that they don't need a scaffold. He was going to build the stairs for it. It was contracted for. Mr. Ibarra testified that it was part of the scope of the work was to build the staircase. And it's clearly incomplete at the time of the accident. And if there's no further questions from the panel, I'm happy to yield the rest of my time.
Anything further, colleagues? Okay. All right. Thank you both.
Thank you.
Okay, the next case is Steele versus NYCHA.
Yes, Your Honor. May it please the court. Ross Maslow, Gore Alventosa for defendant, appellant, Acro General Contracting. Your Honor, it's our position here that the lower court erred in denying our motion for summary judgment. Our client was entitled to judgment as a matter of law. The allegations here are that the plaintiff was walking down a sidewalk and he was directed by a group of maintenance men who were either guarding or had just received a delivery on the sidewalk to walk around the delivery. And
well, isn't there evidence in the record that these people who were at the site could possibly have been your client's employees?
With all due respect, Your Honor, no, there is no evidence of that. All the evidence in this record suggests that these were, well, the only evidence comes from plaintiff himself, who says that the men who were receiving this delivery or who were guarding these materials were wearing a uniform. And the testimony from all parties to this action is that our client was not wearing a uniform, or our client's employees, that it was NYCHA employees at the site who wore uniforms.
But counsel,
Go ahead,
I'm sorry.
Judge Gonzalez.
counsel, did ACRO provide any records whatsoever to show who was working or not working on the date of the accident, or any records or witnesses to show what the condition of the sidewalk was on that day, or any records to show what the condition was of the sidewalk shed or the tree pit? I mean, where were the records here? Where were the witnesses here?
Well, Your Honor, respectfully, I believe we carried our burden without those records. I don't know if the records were required. Discovery was conducted here. We provided what was asked of us. The records are that, and all the witnesses who testified said we had nothing to do with the sidewalk on that side of the building. All of our deliveries came to a staging area on Union Avenue, not on Home Street. This is NYCHA employees themselves who say this. We didn't get testimony. We have testimony from our vice president who says there's no way we could have gotten a delivery on that street because the only hoist at the job site was on Union Avenue, not on Home Street.
Who was responsible for the shed? I thought there was a shed that had been constructed.
There was a shed that had been constructed, Your Honor, but again, with all due respect, it has nothing to do with this accident. Plaintiff doesn't say that shed had anything to do with his fall. He says that he was directed around this bunch of this pile of materials by the workers who were standing there in uniform. He walks around them. When he tries to get back onto the sidewalk, he steps into the area between a tree well and the sidewalk. It's uneven, and that's what causes him to fall. He never entered the sidewalk.
Part of the shed was also constructed in the tree well, was it not?
That's correct, Your Honor. But the testimony from one of the witnesses is that the condition of the tree well was exactly the same for 20 years before this accident occurred.
I thought that there was expert testimony regarding the construction of the part of the shed in the tree well and how that would have led to some erosion or issues with the tree well.
Well, to the extent that the expert who said that, or to the extent that he actually said that, and I think his testimony was a little less exact than that. The fact is, we have a witness who lives at the premises, who worked for ACRO, who said the condition was exactly the same for 20 years before this accident occurred. So, to the extent that the expert testified to that, his conclusion is not supported by facts.
Well, why would it not simply raise an issue of fact?
Well, it can't be an issue of fact because it's not a fact. He's concluding something that's belied by evidence in the record.
Wait, Counsel, this is Judge Scarpula. The condition of the tree well isn't a factual issue?
Oh, he wasn't there on the day of the accident. He can't testify to the condition on the day of the accident.
I'm just asking you whether that's a factual issue and if there is disputed evidence about it. Doesn't that raise an issue of fact?
Yes, Your Honor, but there is no disputed evidence. There is testimony from one witness. That's it. Nobody else testified. There's no measurements. The expert wasn't there to testify as to what the condition was on the day of the accident. There's no disputed testimony as to what the condition was like on that day. There's testimony from one witness, and she says that tree well looked exactly the same for 20 years.
Well, there's testimony of two witnesses, because the plaintiff testified as well as to having stepped into the tree well. So there are really two witnesses, right?
That's true, but he doesn't say that the sidewalk shed had anything to do with the condition. He doesn't even mention the sidewalk shed in his testimony, in his bill of particulars, or in his complaint. Doesn't say anything about a sidewalk shed. He says the condition is the difference in elevation between the sidewalk, the concrete sidewalk, and the lower level of the tree well. Respectfully, Your Honors, if all we're looking at here is an expert's conclusion that is not based on the facts in the record, and the fact is only that it was in the same condition for 20 years. It's the only established fact we have here. It's uncontradicted.
All right, Counsel, you'll have some time on rebuttal.
Okay, thank you, Your Honor.
Okay. The plaintiff respondent?
May it please the court, Your Honors, can everyone hear and see me?
Yes.
Yes.
Okay. Your Honors touched upon the biggest argument that I want to focus on is the complete lack of evidence from defendant in regards to anything happening at the job site on the day of the accident. One witness, the vice president of the company itself, states he doesn't know what time he got to the job site, doesn't know how long he was at the job site for, and he was given multiple times during his testimony to elaborate on any knowledge he had of deliveries, people that were working at the site at the time. And every time he said, oh, I have records for that. Oh, I haven't looked at the records, but I have records. I had phone
But did he
calls.
not testify that there were no that deliveries would not have been made from that location or at that location to the shed, that the deliveries would have been made at a different location?
Your Honor, he did testify to the general practices of the job site of getting deliveries at the staging area. But as the case law cited in our brief, it states that they cannot simply rely upon the generalities of their general practices to prove any particular facts at a given time. It was on defendants to meet their burden to show on this day those actual practices were put into effect, and defendants have completely failed to do that. And again, their witness was asked to prove any of the knowledge he had about deliveries that day, about workers that day, and failed to do that completely. Additionally, the witness did admit that there was work being done on the home street side of that complex. The witness plaintiff, who is the one who has firsthand knowledge of the accident, says that it was building materials that were on the sidewalk at the time. That raises question of facts of them bringing building material to that sidewalk, unreasonably obstructing it. And additionally, defense keeps saying uniforms. Again, there's no testimony in regards to what their workers were wearing at the time. If all of them were wearing blue shirts and jeans at the time of the accident, that could, to a layperson, seem as if that is a uniform for a company.
But NYCHA employees wear uniforms as well, if I'm not mistaken.
And that is correct. That is correct, Your Honor. And again, I'll always point back to defendants' lack of any sort of specificity in their testimony or in their proofs. Defendants had the ability to say, okay, here's our records. We had A, B, and C employees that day. Here's our records of stating that this was delivered on this day or this wasn't delivered on this day. Defendants had to meet their burden of showing that deliveries were not made to that area and who was working at the time of the accident. Defendants could have put forward records that state, we didn't have workers on the job site on that day. So, but again, when asked at his deposition, the vice president says, the records show it, the records show it, the records show it, but nothing was ever produced. Nothing was ever in his own knowledge. He referred to records that were never produced. And when asked, he would say, I don't know, the records would state it. In addition, to the tree well itself, yes, our expert states that there is a question of fact whether or not setting up the shed in the tree well exacerbated the problem, which would raise a question of fact whether or not defendants exacerbated or launched a forced instrument of harm, not only in the tree well, but also by obstructing the sidewalk and directing plaintiff into that defect itself. And Your Honors, if there are no questions, I would yield my time and rest on my papers.
Any further questions? Thank you, Counselor. Right. Respondent Nisha.
Good afternoon, Your Honors. I just want to start by clarifying a couple of factual issues that ACRO didn't describe accurately. Looking specifically at the tree well issue, this case is not about a sidewalk defect, it's about a tree well. Now, normally the city, which is not a defendant here, is responsible for tree wells. Clearly here, ACRO had sole contractual responsibility, as is made clear from 806 of the record. But looking again at the testimony about the condition of the tree well, Mr. Steele at 445 to 446 of the tree well describes about a 6-inch height differential between the sidewalk and the tree well. Then you go forward to Kavardia Cummings, who not only lived there for 20 years, but also worked on this site. Around pages 1163 to 1165, what she says is in the past, that height differential was minimal, a little bit, were her words. And so looking even at her generic difference or estimate of the differential, The testimony appears to show that that height differential doubled by the time of Mr. Steele's accident. And again, as the plaintiff has already explained, ACRO didn't come forward with any information to show that they ever inspected that tree well, to make sure that their installation and ongoing use, again, not on the sidewalk, but above the sidewalk, that it didn't somehow exacerbate and cause the height differential to change over time. And to the second point, again, so on that basis, this court can affirm because ACRO didn't meet its affirmative, didn't establish its prima facie case. But then there's also the alternative basis of whether or not it was ACRO's employees versus NYCHA's who directed Mr. Steele off of the sidewalk and into this dangerous area. Now, Mr. ACRO harps on the point of uniforms, but if we look at page 792 of the record, this contract clearly required ACRO to provide a range of things that are very uniform-like: hard hats, vests, gloves, boots, goggles. Mr. Steele was unable to provide any detail, even as to the color of the uniforms worn by the individuals he encountered. And beyond that, I'll just note that the issue of deliveries is something that Kavardia Cummings, which was ACRO's employee at that time, talked about. Around, again, pages 1163 to 1165 of the record, she shows how she and other members of her crew transported scaffolding materials from the Davidson houses to the St. Mary's houses in June 2012, and that they worked until around 4:30 some days. So again, on that alternative ground as well, there are material issues of fact as to who these workers were. And these are issues that ACRO could have come forward with to show some documents or a person with knowledge say who was where, but they didn't. So on that basis, too, this court can and should affirm the denial of summary judgment.
Thank you, Counselor. Mr. Maslard?
Yes, very briefly, Your Honor. In rebuttal, yes. First of all, as far as the uniforms go, that's not something that's really subject to any kind of discussion, I don't think. Everybody knows what a uniform is, and we're not talking about a hard hat. That's equipment. That's not a uniform. A uniform is what people are wearing. It's the clothes that they're wearing. I think he was very clear that the men standing around this delivery were wearing a uniform, and ACRO employees did not wear any such uniform. But more importantly, both the respondents talk about discovery that they say could or should have been exchanged. The fact is that the note of issue was filed here. Discovery was completed. There were no motions made saying that there was discovery outstanding. They had whatever they wanted, and they don't have any evidence to suggest that there were deliveries being made. And the final point is, our executive vice president, he can't prove a negative. All he can say is, I was at this job site every day, and I'm saying it was impossible for us to get deliveries on the Home Street side of that building. We had no hoist there. We had no equipment that we could move the materials with. Everything was delivered to the Union Avenue side, and that's confirmed by Mike Peterson, who is the maintenance supervisor for NYCHA, who says that he discussed the deliveries with ACRO and knew that they were being stored on the Union Avenue side of the building.
But counsel, the vice president of the defendant company referenced records that were never produced. Doesn't that create problems? We keep going back to the same issue.
Apparently, it wasn't a problem for plaintiff or co-defendant, because if it had been, they would have made a motion. Apparently, they didn't think they needed it. He testified. They were happy with his testimony. They didn't make any motion afterwards. They didn't serve a discovery request asking for any documents. They accepted his testimony. That's what they did. We would suggest that the lower court order should be reversed and the complaint should be dismissed against ACRO. Thank you, Your Honors.
Thank you. Thank you all, Counselor. Okay. The next case for argument is Williams versus the City of New York.
Good afternoon, Your Honors. Can you see me and hear me?
We can.
Thank you. Two independent reasons require reversal here. First, plaintiffs failed to allege and prove that the city owed them a special duty of care. And second, the governmental immunity doctrine applies because the city's acts here were inherently discretionary. To the first independent ground on special duty, it's undisputed that the city performed governmental functions here. It's also undisputed that loss of sepulchre claims are not exempt from the special duty requirement. The only exception this court has recognized is that a special duty can be implied when a decedent's identity is, quote, immediately ascertained upon discovery by police. In other words, there's no investigation necessary, whether to determine the identity of the decedent and of next of kin. What plaintiff here is trying to do is to force a square peg into a round hole. There is no dispute in this case that police discovered a John Doe after a member of the public had said there was a foul odor emanating from an apartment. And when they went to that apartment, they found no identification whatsoever on the person, on the deceased, or in the apartment.
Let's fast forward this, because they did do an investigation, correct?
They did.
Right. And during the course of the investigation, they obtained some medical records, did they not?
The medical examiner's office obtained chest x-rays for a person that they called Keith Williams. And based on the examination of those chest x-rays and examinations of the chest of the deceased, they made a match. That's what happened. So
in other words, they had Keith Williams' medical records.
No, they had Keith Williams' chest x-rays. There's absolutely no evidence.
How do we know that it was limited to just the chest x-rays? How do you get chest x-rays without getting the medical records?
2 points on that, Your Honor. The medical examiner's role here was to identify cause of death, which they did. It was based on chronic drug abuse and other particular
autopsy, right?
Yes, and the second one was to identify this person who was a John Doe. There was no way to. It
was part of the investigation, right?
That's correct. They were not. Okay. They were not tasked with identifying next of kin, which is what the city was. And we produced, Your Honor, the certified medical examiner case file. This is on page 639. There is no next of kin information in the case file. So what plaintiff is trying to do is rely on mere hope and speculation that
I have two questions. I understand it's a John Doe, but this individual was found in an apartment. Yes?
That's right. Yes.
So how difficult is it to ask a superintendent or a landlord of the building, or even other individuals in the building who resides in apartment, whatever?
So the officer did talk to a superintendent, and the superintendent, they went there based on the fact that Keith Williams had several addresses there. So they asked the superintendent, and the superintendent, I believe, confirmed a person named Keith Williams lived there. But the superintendent said that he never mentioned any family and had no visitors. And I want to back up and say all of this is discretionary action, Your Honor. So if you don't find special duty,
so let me ask you a question, because if in fact they were in possession of material that identified the next of kin, would that convert it from a discretionary action to merely ministerial?
Sorry, can you say the first part again?
If they were in possession of information identifying next of kin, would that turn it from a discretionary investigation to a ministerial act of notifying the known relative, next of kin?
Well, an investigation remains discretionary unless there's a governing statute or regulation that commands a compulsory result. There's no such thing here to make it non-discretionary. But
so let me just interrupt you for a second. This is Judge Scarpura. So you are saying, if I know who the dead person is, I don't have a ministerial duty to tell the family? Of course you do.
That's not quite what I said, but I was saying that.
Let's assume. So the question that Judge Gish was asking is, if you know, isn't it a ministerial duty to tell the family? If you have that information It's not discretionary whether you tell the family. You've got to tell the family, correct?
Well, if you just know the identity of the decedent and you don't know who the next of kin is.
Assume that you have both those pieces of information.
Right. Assuming you have both those pieces of information under Court of Appeals case law, it's not ministerial unless there's a governing statute or regulation. And what I was about to say is
today, let me just finish this line. So in this case, you know who the dead person is, and you have his medical information that names his next of kin, correct?
We don't have his medical information, Your Honor.
On the chest X-ray, in that group of medical information, it names his next of kin, correct?
It does not, Your Honor. The chest X-ray is all that the medical examiner had, and I think this is a very crucial point here. The plaintiff keeps saying that we have the next of kin information. We did not. The plaintiff found the next of kin information after discovery was closed. Plaintiff then served a subpoena on the hospital, and the hospital produced it from its electronic files. There's no evidence that the police or the medical examiner had that information. That's what I was trying to stress.
So you're saying that all they had was I won't say a piece of paper, but all they have is one thing that is the X-ray. You just have an X-ray that has the deceased name on it, and there's nothing else that accompanies that X-ray other than that's it. The chest X-ray. There's nothing else there.
What the record shows is that the city had the chest X-rays. Again, that's because the medical examiner.
How do you get a chest X-ray with someone's name on it, not attendant with any other medical record? How do you just get a lone chest X-ray? And how do we know that this is his?
Part of the only basis we think the remains is his is based on this chest X-ray. There was no other way to identify this person. He had no teeth. The decedent was unfortunately.
I think you're not answering the question, though. How can you get a chest X-ray without anything else to otherwise identify it to the person who it purports to have an image of?
I think you can
how
get it.
could you not have further medical records?
I don't understand how you just get a single chest X-ray. So you have a chest X-ray and it says Keith Williams on it, and that's it? I don't understand.
I think that's because, again, the medical examiner here was tasked with simply identifying the body and conducting the autopsy. So.
All right, I think
okay.
You're out of time, so I'm going to ask you to wrap up your argument. You do have some rebuttal.
Sure. Just very briefly, I understand I do have rebuttal. Thank you, Your Honor. All of this, again, is based on the fact that this is an independent ground for reversal here, which is the governmental immunity. So if you don't find special duty, you don't need to go into whether or not the government's actions here were ministerial. And I'll wait for rebuttal. Thank you.
Thank you. Counsel?
Good afternoon, Your Honor. Nicholas Timko for the plaintiff respondents. The Williamses. The defendant completely ignores the precedent here, the Rogova case and the Tinney case, okay, and the law that it establishes. When a person dies, there's a duty to notify the next of kin. By definition, it is a specific duty. It's not to grab some random person off the street and say, hey, I got a dead guy here. It's to notify the people that are related. If you look at this order from the trial judge, denied their motion for summary judgment and said there are questions of fact. They didn't submit any evidence that said how we got this mysterious X-ray or how we didn't have any of this other information. They identified a name. They got Metropolitan Hospital records. In order to know there was an X-ray in existence, you would have to, of necessity, look at the record to see, oh, they took some X-rays. We have an X-ray. We can compare the two of them.
So, counsel, let me interrupt you first and just ask you, for example, is there anything in the record that says all they got was the X-ray that says the decedent's name on it?
Nothing else? No, in fact, they submitted an affidavit from the after note of issue is filed from the medical records office and says, after completing an x-ray comparison of x-ray obtained from Metropolitan Hospital. They didn't say how they got it. They didn't say we only got an x-ray. They didn't say we got the record and we went through it and figured out he had an x-ray and we investigated the x-ray. There are plenty of fact issues here as to whether, and if you assume that they had that medical record, which we subpoenaed for the motion so that it would be an admissible form, the document, so that it could be submitted to the court to show that the electronic, they have access to the medical examiner. It's electronic record. They have access on a computer. It's
So,
a matter
Mr.
of
Timko,
it.
Mr. Timko, this is Judge Gonzalez. So what is the role of the chief medical examiner versus the role of the police in this situation? Counsel is relying on the role of the chief medical examiner as far as simply making do with the x-ray and not going any further. What role does Rugova play here?
Well, the claim is against the city, also naming the city's medical examiner and the city's police department, which is all part of the city. Okay, so you can't say, oh, this cop didn't have it in his file, but it was in the file of the cop sitting next to him, so we didn't have it. The Tenney case doesn't say immediately accessible. It says when you have the necessary identifying documents, which they had, all they had to do is look at them. If I have the name in my file and you ask me for the name and I say, sorry, Judge, I don't have it, but I could open a file sitting in front of me and give it to you, does that mean I didn't have it? And that's a semantic game that they're playing here. The investigation was horrible, and there's a lot of conflation of the investigation with what ultimately happened when they identified him. And they're trying to use the investigation aspect to say, well, we did a terrible investigation, but we're allowed to be, incompetent in our investigation as long as we get our governmental immunity. But whatever happened with the investigation, on the date that they identified him in late July, the medical examiner has the medical records. The documents are all there. The databases that all they do is look at them. You can't argue willful ignorance that I had the documents. The information was available to me. I chose not to look at it. Therefore, that was an investigative issue. It wasn't. It was a ministerial act of I had it in front of me. I had it available. I just didn't open it up and I didn't just look at it. And therefore, I get governmental immunity.
So this is Judge Scarpullo. So your position is basically that there is enough evidence or enough issues of fact here for me to be able to show a jury that they didn't just have the x-ray. They had the actual medical records which showed the next of kin, and they knew, and from that they could both identify, and then at that point they had the ministerial duty to tell the family. Is that your argument?
Yes, the next of kin were identified there. All they had to do was, there was a phone number in that record too. All they had to do is dial the number.
And whether or not they had the full record or the part record is an issue of fact that we should let it go.
That's why the judge didn't grant us summary judgment. If there was proof that they had the full record, we get summary judgment. If there's proof they had nothing else, they would, but there wasn't this information in the record and it's not party evidence. So therefore, that's why they denied the motion to both parties. Unless Customer has any other questions, I yield my time.
Any questions, colleagues?
No.
Okay. Mr. Lee, your rebuttal?
Thank you, Your Honors. 2 points. First, on the special duty issue, we're not ignoring precedent. Rugova and Tenney is very clear that for that exception to apply, the decedent's identity must be immediately ascertained. And here's why this court chose to limit it that way. If you don't limit it that way, you're allowing plaintiffs to bring, all sorts of plaintiffs to bring claims against negligent investigations, which is what this is here.
I'm looking at... I'm sorry. I'm looking, go ahead. I'm gonna yield to Judge Weber. I'm looking at Rugova, which I was on the panel, and and in that case, certainly factually, they had the information immediately, but where does it say that you can't have the claim unless it's immediate? I don't know where you're reading that from.
Well, because the case says immediately ascertained, it cites the Tenney case, which is sort of the exact same fact pattern, and it says under the circumstances presented in this case. And the reason I was about to explain, the reason why it's so limited is because if you allow plaintiffs to bring claims against situations where police discover an unidentified person, a John Doe, and they later find out who this person is, you're basically bringing a claim for negligent investigation. In both Tinney and Rogova, the plaintiffs there, the decedents there.
That's actually not true, because the right here is the right to the remains, and whether they're identified or not identified, there may be an investigation, but it's not for a negligent investigation. It's the right to the remains. When you have sufficient information or facts that would indicate that you could ministerially notify next of kin, why does that duty only apply to when you immediately know who the identity of the body is? I don't see it in that case, and I understand your reasoning, but I don't see that reasoning in the case either, and I don't think the reference to Tinney does it for you either.
Both those cases involve situations where the decedents were immediately discerning. But even if we want to...
That's just happenstance. There's nothing in the decision that says this is limited to circumstances where the body is immediately identified. That's the leap that you want us to make from this case. And quite frankly, I just think you're reading too much into the case. Maybe you think we should make that limitation, but I don't see that it's a binding precedent from that case that we are required to follow, quite frankly.
Well,
I just don't see it.
In that decision, it specifically distinguishes that case, Rogova, from Gabrielle, and it says there was no need for any investigation in Rogova. Well,
there was a point here where you had the information and there was no need for investigation.
So that's my second point, Your Honor. I do want to get to that. We don't have the information. We produced the certified medical...
That's a different issue. And your adversary, and you argued on your direct case that there's no issue of fact. He said yes, issue of fact. That's a different issue.
Well, that's my question. Is it your position that you don't have the information because you're not privy to the information that the medical examiner had, or that you should not be privy to the information that the medical examiner had?
No.
Because the medical examiner has access to the database, and the database has the chest x-ray of this individual. Then it would seem to me that all you had to do is get the additional medical records that were attended with that chest x-ray, and then again you would see who the next of kin was. So so you're saying that that is something that you should not be privy to, or you were not privy to, or that's something that is separate?
Your Honor, thanks for giving me a chance to correct that. I'm not at all arguing, as plaintiff is asserting, that somehow the police and the medical examiner aren't privy to what each are knowing. My point is, in this case, there is no evidence that the medical examiner actually had next of kin information, which, by the way, was with the hospital. It wasn't with the medical examiner. I think he wants to conflate that and make it about how the medical examiner had the information. We produced the certified file in the record. There is no next of kin information. So this is not a situation of one police officer's files and the next police officer's, the next death's over and they're not sharing information. The city simply didn't have it. And while we can say that the police officer and maybe someone at the medical examiner should have done the next step, and the next step of the investigation being, wait, we have the chest x-rays, let's maybe ask this hospital or another hospital if they have next of kin information. Unfortunately, the city employees didn't do that, but that's a discretionary decision that they made. And unfortunately, as incompetent as that may be, that does not mean plaintiffs have a claim.
Okay.
Thank you, Your Honors.
Thank you. Thank you both.
Thank you.
Okay, the next case is Live Nation versus Greenwich Insurance.
Good afternoon. Ready?
Yes.
Jeffrey Moran on behalf of the Live Nation entities, which I will call Live Nation for the purposes of...
I just want to ask you a preliminary question. I won't even take it off your time. Why is this case sealed? Why is the file sealed? It came to us marked sealed.
I don't know the answer to that.
Okay. Thanks for the answer. Go ahead.
I don't.
All right, I believe you. You know,
the only
maybe
thing
we'll unseal it. Yeah.
The only thing I can imagine is way back when, perhaps when the policies were being exchanged, that there was a confidentiality order based on the policies. But other than that, I don't know why this was marked sealed.
Okay. Thank you. Go ahead. You can proceed.
We are here respectfully asking this court to reverse the lower court's ruling that there's no duty to defend Live Nation on behalf of the insurers, and that that there's no coverage under the policies issued by the insurers. In terms of the duty to defend, this court is well aware of what the standard in New York is, requiring an insurer or insurers in this case to defend. At the time that Mr. Perez in the underlying case, this is a very convoluted set of matters. There's been up and down to this court several times in both the underlying case and this case. But at the time that Mr. Perez filed his complaint, when the allegations contained in those four corners of that complaint are read both liberally and objectively, there was a reasonable possibility of recovery against Live Nation under these policies, and these insurers were duty bound to defend Live Nation at that point. In fact, that is highlighted and redlined by the fact that 5 years after the complaint was filed in 2018, Judge Engoron in this case denied summary judgment to the insurers, specifically finding, and we think he made error by not considering all the endorsements, but he specifically found the possibility still existed in 2018 under one of the endorsements, the designated person endorsement, that coverage might apply depending on what was found with regard to Mr. Perez's negligence. If in 2018 there was still a possibility that coverage was out there, then these insurers breached their duty from 2013 onward in refusing to defend Live Nation. And we respectfully submit that there was a reasonable possibility of recovery under four other endorsements. The property manager endorsement, where liability would arise out of the presence and entry onto premises endorsement, the managers or lessors of premises endorsement, where if the responsibility or liability on behalf of a manager of a property or a lesser of property rose out of the ownership, maintenance, or use of premises, that as of the date the complaint was filed would be reasonable possibility of recovery under that endorsement. And the lesser of leased equipment, because as your honors know, what was being erected at the time of Mr. Perez's accident was in fact a metal structure where pieces of metal had been brought on. Well, part of it had already been erected, and then Mr. Perez delivered and brought onto the property pieces of metal to erect a second story to what was called an on-site display booth, which was a designated space for Best Buy, who was the contracting party with Live Nation, for Best Buy to erect this display booth.
Yeah, under your argument, though, if any one of the endorsement implies was a possibility, then your client would be entitled to a defense, correct?
Correct.
Okay.
And we think that, and we respectfully submit to your honors that under any of those, that the duty to defend had been breached, and it is inured to the financial detriment of Live Nation, and this court should reverse Judge Engoron on that count, and should instate the defense duty dating back to the filing of the complaint. With respect to coverage, and it goes hand in hand with the reasonable.
Well, listen, doesn't coverage just end because at the end of the day, Best Buy was let out of the case? No liability, no negligence in Best Buy, or Perez.
No.
So
no.
why would you get why would you get coverage under the policy for that?
Because under the sponsorship agreement, which is the contract between Best Buy and Live Nation, Best Buy was directed and mandated to purchase insurance, naming Live Nation as an additional insured under a policy for any and all claims arising out of Best Buy's operations. Clearly what occurred on the day of the accident was Best Buy's operations. Mr. Perez was on site for to erect Best Buy's display booth. He was Best Buy's contractor. And when the erection of the booth had been completed, Mr. Perez was there to install and deliver Best Buy's advertising. So clearly the accident arose out of Best Buy's operations. The fact of the matter is that the clear intent and reasonable expectation of both Best Buy and Live Nation was that this insurance policy was purchased pursuant to that sponsorship agreement obligation and was intended to cover Live Nation for any and all claims arising out of Best Buy's operations. There's one, the first, I'm running out of time, but the first endorsement, which is the owner, landlord, and property manager endorsement, which reads.
Counsel, if I may, it's not just Best Buy's operations. It's not like carte blanche. It's more Best Buy's acts or omissions. So if Best Buy didn't do anything that was wrong, if Best Buy wasn't liable, then you don't get indemnified, right?
That is potentially accurate on only 2 of the 5 endorsements. 3 of the 5 endorsements have no fault-based requirement in them. And the endorsement that I was about to read to your honors reads as follows. And this is the owner, landlord, and property manager additional insured endorsement. Any building owner, landlord, or property manager from whom you secure permission to enter premises for the purpose of delivering to and or servicing and or installing a product for your customer, and to whom a certificate of insurance has been issued reflecting such status prior to the loss. Such person or organizations or additional.
No, you don't have to read it to us. We read it. But I read that as sort of pertaining to Best Buy's deliveries, which is not really what occurred here. Well, they were delivering goods here, and they had to have a certificate of insurance for the delivery of the goods to the premises.
Well, here's the problem with that question and the analysis, because I think you'll probably hear that from counsel. None of those terms that I just read to the court is defined by the policy. Delivering is not defined. Servicing is not defined. Installing is not defined. Product is defined. It's the only term in this endorsement that's defined. And product is defined as any goods, or any product handled, distributed, disposed of by Best Buy or somebody on its behalf. So what Perez was doing was he delivered material on behalf of Best Buy so that it could erect the second level of Best Buy's vendor booth, according to the allegations in the complaint and the facts. He delivered on behalf of Best Buy the advertisement that was going to be affixed to that. And the whole purpose of the
it's an interesting, I will say, I'm familiar with your argument, and you're out of time. It's an interesting argument. It sounds a little like a shoehorn to me, but, we'll look at it. Okay, let's hear from your adversary now.
Good afternoon, Your Honor. James Ruggieri for Appellee's Greenwich Insurance Company and XL Specialty Insurance Company. Your Honors, I do want to start by making a point, because the court indicated it would look at things, and it should, because words really matter. They matter in the complaint that Perez filed. Perez alleged in the complaint that Live Nation was solely negligent for his injuries, and that's at the record at page 89.
But that's not the end of the story, though, right? There still was a potential there was a third-party complaint. There was potential for people to point fingers in other directions, and one of those directions would have been Best Buy.
Your Honor,
Perez.
all right. There actually was not the potential, and actually I would draw the court's attention to the recent case decided 5 days ago, Citizens Insurance Company case, where Judge Gonzalez sat on the panel, and also the Brickman, Port Authority versus Brickman Group case, where Judge Weber sat on the panel. The court was very clear that in those contexts that the alleged additional insurers were entitled to defense cost coverage because the complaint allegations expressly said that the named insured was approximate cause or was negligent in the case of the Brickman case of the water discharge.
That's true. That's principle of law. That would be true. But that doesn't mean that if it's not in the complaint that it can't otherwise arise in the context of the potentiality of the litigation. Does that?
Well, Your Honor, the complaint, and if you go back to the parties' briefs, we actually agreed that the 8 corners set the table for the duty to defend. You read you measure, you apply the complaint against the policy, and that's what determines whether there's a duty to defend, and the cases are legion in New York on that issue. I will say that to the extent that the courts have gone outside, it's in the context of a special duty. The only cases I'm aware of where they've done that is in the context of an employer-employee, where the employee doesn't name the employer as a defendant because of workers' compensation reasons. And then a subcontractor, non-employee third parties into the employer, and the courts have said that's a circumstance where there's a special duty to go.
Can the third party complaint be looked at in the context of figuring out coverage?
Your Honor, it cannot, because a third party complaint was never served. And under the rules, after 120 days, is subject to dismissal. And frankly, the time bar has come for Perez to bring a claim against Best Buy for his injury. So no, that's an extraneous document. That's not part of this record, not part of this case. It really has nothing to do with the analysis under the cases that make it very clear New York's an 8-corner state, except for the situation of an employer-employee. I would also say that the duty to defend, Your Honors, presupposes the existence of a suit against the named insured or the additional insured. The potentiality standard really goes into the scope of the coverage, again, the claim against the named insured or the additional insured. It doesn't go into figuring out in the first instance whether the first prong of the duty to defend, is there a suit against someone who qualifies as an named insured or an additional insured. The potentiality goes into the second prong, which is, okay, once you have that, are the allegations potentially sufficient to trigger coverage under the grant of coverage under the policy covered bodily injury, for example? Your Honors, again, words matter. Counsel mentioned the sponsorship agreement. My clients aren't a party to the sponsorship agreement. The Bovis Lend Lease case makes that clear, that my party's obligations are governed by my insurance contracts, not by the sponsorship agreement, which is a totally different document that's subject to a totally different litigation that doesn't concern my client. Here, the appellants have said that Justice Moran didn't address and ignored the 5 endorsements. He did not. If the court looks at the record at 19 to 20, he addressed every single one of the endorsements that the appellants raised. And frankly, Your Honors, it's actually 3 endorsements that have the caused by language in it. So under those 3 endorsements, Live Nation is only potentially covered for bodily injury that was caused by Best Buy or Perez. And for the other 2, we're not talking about the delivery, installation, or servicing of products. There are no customers here. We're talking about the construction of a display booth to display products, not to sell products. And he ignores that you're supposed to be on site to deliver, install, or service the product to a customer. There are no customers on site. It was a display booth. That's all it was. And with regard to the lease issue, Your Honors, there was no leasing of equipment or premises here. There was actually, the testimony down below was that Perez was the one who actually bought the trust and billed Best Buy for the trust. And he said that trust was Best Buy's trust. And with regard to the lease of premises, there's no lease of premises here. Live Nation actually retained the right to cancel my client's right to use the premises for any reason whatsoever other than a force majeure event. It had the right to cancel the contracts and terminate my client's right to be on the premises for, quote, any reason whatsoever and other than a force majeure event, Your Honors. That is not a lease. That's not an exclusive right to possess. That is a licensee. I'm there as long as you'll let me be there, and if you don't want me to be there, then I'm not going to be there any longer. Your Honor, with regard to, I do think it's important to say that Justice Ingoran was correctly right applying Burlington to the case. Cause in whole or in part, no one disputes proximate cause. That's why he correctly said that Live Nation is an additional insured if and only if Best Buy or Perez caused the injury. And then he went on to note that Justice Leibovitz in the underlying suit ruled that Perez was Best Buy's contractor working for Best Buy. And that's really, really important, because if Perez was working for Best Buy, Judge Ingoran was absolutely right when he said any negligence of Perez would have been attributable to Best Buy in that context. He's exactly right. He did not rule that Perez was an independent contractor whose acts weren't attributable to Best Buy. He ruled just the opposite. He said over Best Buy's objection, Perez is Best Buy's contractor, on therefore Best Buy. And because of that, then Justice Ingoran was actually correct in making the second ruling, which is that ruling by Justice Leibovitz 3 times that Best Buy was not negligent meant that Perez wasn't negligent either. So Perez was there for Best Buy, and Best Buy wasn't negligent. His acts were attributable to Best Buy. And it's also interesting, if you go to the three endorsements that had the cause by requirements, Your Honors, if Perez wasn't there for Best Buy, who was there for Best Buy? Nobody. And if nobody's there for Best Buy, then obviously Best Buy and Perez couldn't have caused Perez's injuries. The only way they even potentially have a claim under those 3 endorsements is to argue that Perez, his acts were attributable to Best Buy, and that's what gives them right to bring their claim for coverage under those endorsements. But, Your Honor, I would urge the court to review the Citizens Insurance Company case, to review the Port Authority versus Brickman case. It's very clear that we're talking about the 8 corners in New York. This is not a special arrangement. We don't go outside the 8 corners. We look at the 8 corners of the document, and the allegation by Perez that Live Nation was solely negligent in his complaint controls the duty to defend issue. Quickly, judges, there's no 3420 issue. I'm not relying on a policy exclusion, and I'm not relying on a breach of a condition to coverage. I'm saying they're not an additional insured under coverage. So under the Worcester case and the Zappone case, we don't have a 3420 issue here.
Wait, counsel, this is Judge Scarpullo. What about the third-party complaint alleging indemnification? That third-party complaint alleging indemnification triggers the obligation of the obligation to defend. It doesn't just have to be in the main action. There's a third-party action.
Your Honor, it actually does need to be in the main action, because otherwise you as the putative additional insured are invoking a duty to defend, not by the claims that are being made against you, but by your prosecution of a claim against somebody else. So I do disagree. I do think that it's Perez's complaint allegations that set the table. Otherwise, the duty to defend would always be triggered on the basis of your prosecutorial claims that you're making against somebody else. And that's
no, but there's an allegation in the third-party complaint that
correct, Your Honor. It's an allegation made by Live Nation against Best Buy. It's not made by Perez against Live Nation. It's a defense, if you will, but it's made in an affirmative context where they are trying to plead on their own and trigger a defense by virtue of Live Nation's own pleading. The third-party complaint is filed by Live Nation against Best Buy, Your Honor.
But I don't think that I think that you can't exclude that and say that under no circumstance then is there a duty to defend. I think that raises, even although the plaintiff didn't raise it, if the third-party complaint raises it and it's a legitimate allegation, why doesn't that kick in the duty to defend?
Because, Your Honor, it's not an allegation made by the underlying claimant against the alleged additional insured. It's actually an affirmative pleading made by the additional insured to try to trigger a defense obligation, not by the claim that it's defending, but by the claim that it's prosecuting. And that's a difference. And there's no support, to my knowledge, in New York case law that allows someone to use a third-party complaint in that instance where they're prosecuting the claim to try to trigger a defense obligation. It didn't affect Perez's claims against Live Nation, Your Honor, which were Live Nation was solely negligent.
I just want to clarify, because you indicated at the beginning of the argument that the third-party complaint wasn't served.
Your Honor, the separate complaint that the appellants have alluded to, I'm sorry, filed by Best by Perez was never served, Your Honor. That's what I thought the court was alluding to.
So, but the Live Nation complaint was served.
The Live Nation complaint was served.
And your argument about that is something different, is that can't serve as the predicate for liability because it was your affirmative complaint.
Correct. That's not a claim that we're being asked to defend. That's a claim that Live Nation prosecuted.
I understand your argument. You've exceeded your time, so I want to give your adversary rebuttal, and I'd like him to address that point of the third-party complaint, because let's assume for a minute that the underlying complaint does not raise the specter of Perez's or Best Buy's negligence. Under those circumstances, can the third-party complaint served by Live Nation serve as a predicate?
Well, it can, but I do think that there is a supposition in your question that is not totally, may not be totally accurate.
I know, maybe not, but I want you to answer the question.
I will answer the question with this, okay, I'll put the proviso at the end. The answer is yes, because it is clear from the underlying, from the pleadings in the underlying case that Perez was concerned when he pled that a defense of workers' compensation might be raised or employment might be raised. And so it was not raised in the complaint, but it was raised in the third-party complaint. And so Best Buy's negligence therefore had to be implicated in the third-party complaint because it wasn't implicated by Perez. That goes to the special relationship or special duty that counsel just alluded to in situations where the four corners of the complaint doesn't necessarily bring about an allegation, because if Perez was concerned and did not plead Best Buy because of workers' compensation considerations, then the only way that relationship was going to be brought into into the underlying case was through third-party complaint. That's number one. Number
counsel,
two.
let me just add, and that would essentially mean that the duty to defend would otherwise be nothing because of workers' comp, because the plaintiff could never bring in that claim, or it would certainly be much narrower, because assuming that the plaintiff's in most cases where workers' comp would prevent the plaintiff from making that direct allegation. So why put in the duty to defend if you don't get the benefit of it?
And yeah, correct, Your Honor. And there's another thing that I want to, a couple other quick points. Plaintiff counsel says that he has nothing to, that the insurers were not parties to the sponsorship agreement and therefore have nothing to do with the sponsorship agreement, and it has nothing to do with them. That is incorrect as a matter of law. Under BPAC versus One Beacon, which is Court of Appeals case, and under Chelsea Piers versus Colony Insurance, which is a case from this department in 2019, both decisions said that courts can look to the underlying contracts, which form the basis of the reasonable expectations for coverage by the parties. And in this case, the reasonable expectation of both Best Buy and Live Nation was that any claim out of the operations by Best Buy would be covered, and Live Nation would be an additional insured under these policies. That is presupposed to be knowledge to the insurer, because the way the insurer wrote its policy, where it said all contracts that you have signed and executed before date of loss are covered under this policy. Therefore, it's an insured contract. Therefore, they are presumed to know what's in the contents of the sponsorship agreement. And the fact that Best Buy in the underlying case fought its claims as hard as it did by saying, we bought the right insurance, you should be insured for this claim, and that insurance should be primary, is evidence of Best Buy's reasonable expectation, and it's evidence of Live Nation's reasonable expectation, and to not look at that contract in context and inform the scope of coverage and inform when the coverage apply to the claims would make that clause a nullity.
Okay, I'm going to ask you You're way over your time, so I'm going to ask you to wrap it up. Obviously, this is a complex matter, and we have your eloquent briefs and the record, but I'm going to ask you to please wrap it up.
Okay. 30 seconds. The lesser of property and manager of property and the leased equipment endorsements do not require fault. They are not fault-based. They are arising out of...
With all due respect, Counselor, you're repeating.
Okay. No, I didn't know. I did not know I went to that.
You did.
With respect to any matter that I didn't...
You're supposed to wrap up.
Yes.
Wrap up.
Any topic I speak, I submit on my briefs.
Thank you. Thank you. No, thank you both. A very interesting and lively argument about insurance. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
All right. The next case is Ixis against Natixis, and you'll tell me if I pronounced that correctly.
Thank you, Your Honor. This is Michael Hampson of Rolnick Kramer Sadigi on behalf of the Plaintiff Appellant Computershare Trust Company as separate securities administrator for the trust. It is Ixis and Natixis.
Okay.
May it please the court. This appeal involves the incorrect dismissal of plaintiff's claims on statute of limitations ground without consideration of all relevant facts. Here,
well, it was a motion to renew, was it not? Renew and re-argue, right? So the threshold is whether you had the right to bring it in the first place, and the lower court stopped you at the door. She said, what did you do this for? You could have raised this argument in the original motion. You knew about here the facts that you were going to rely on or a bankruptcy that occurred years before you brought the underlying motion purporting to put forward a different date for the accrual of the statute of limitations, correct? Did I get that wrong?
That's what the motion court said, but I would submit, Your Honor, but what the motion court was actually requiring us to do is to foresee a change in the law.
There wasn't a change in the law. I don't think so, and here's why. And you can correct me if you, and point out to me the flaw in my reasoning. The issue of when the cause of action under these RMBSs accrued was very much a live issue that was working its way through the appellate courts. And there was one hand that was saying, gee, it accrues when the representations and warranties are made. And there was one line, your line of people who were saying, no, it's when the trustee makes a demand for coverage. So it was an undetermined issue of law that could go either way. The argument that you are raising, or that you raised in your motion to renew, was an alternate accrual date, which was never, there was no change in the law. There was simply no law on that whatsoever. So tell me, what am I missing? What's the flaw in my argument, in my view of the case?
So first off, Your Honor, is when we briefed and argued the motion, the Court of Appeals had resolved kind of the ultimate issue about when the cause of action accrues on the breach of representations and warranties in the case of a securities v. DB structured products. That had been decided. And then that issue here was this independent backstop obligation of the sponsor. And ACE had said that the cause of action against the lender accrues when the representations and warranties were made. Defendant moved to dismiss our case and said that no, that applies equally to the independent backstop.
To the backstop, right.
So,
and that was the open issue.
And we said at that time that's not true. Under New York law, right, an independent backstop, a guarantee, is not dependent on the underlying breach in terms of the statute of limitations argument.
Correct.
And
that was your argument. But here's the question. Why couldn't you at that time also say, alternatively, if it didn't accrue when the demand was made by the trustee for the backstop to be fulfilled, than it otherwise accrued in connection with the bankruptcy, at least as to the cause of action regarding this one particular originator.
First LLC.
Yeah.
That wouldn't have responded. That would have made a tiny bit of difference based on the argument the defendant was raising. The defendant
it would have made this action timely if you had succeeded.
Not
Otherwise, why are you making the motion to renew?
No, not. But
yeah.
All due respect, not under the defendant's argument in the motion to dismiss. It would have still said, well, it doesn't matter when the bankruptcy was because the backstop was triggered when the breach of representations and warranties were made under ACE, right? And at that time,
that's right.
Right.
That would have been the argument.
New York at that time, it was the American Training versus Fish. It is a bit of an antiquated Court of Appeals opinion, but in that case, the court said that the fact that the statute of limitations has run on the underlying obligation isn't a defense to the statute of limitations on the guarantor. And so what we would have to have done would assume that the appellate division in Bank of New York versus WMC would have made would have actually said, okay, we've got the Fish law, but in the RMBS context, we actually think that the running of the statute of limitations on the underlying obligation is something that matters, right? So we would have it's a standard of whether we had to foresee this. Putting yourselves in our shoes at that time, that is not something that we could possibly conceive of. It wasn't until this court decided Bank of New York Mellon versus WMC, where it actually agreed with our interpretation of the backstop obligation. It said the backstop obligation is an independent obligation, and you don't have to bring your case within the statute of limitations for the breach of representation and warranties. But it added this twist, and this is the twist that I thought was at odds with Fish. And this is the twist that required us to go looking back at the record and see if there were additional facts that fit within this paradigm. And the twist was that the backstop obligation had to be triggered at a time when the breach of representation and warranties cause of action could have been brought. And so,
Counsel, this is Judge Karkoa. Why is that a twist? That's true in every single possible case.
Your Honor, I don't believe that's true, because if that were true in every single case,
you couldn't relate back if you could. I mean, that's just a general proposition that would be true regardless.
No, the law in New York prior to Bank of New York Mellon, under Fish at least, is that the guarantee can be a broader obligation than the underlying obligation. So in that case, the 4-year statute of limitations against the principal had expired at the time that the guarantee claim was brought. And that was the exact same argument that the defendant in that case made. The defendant in that case said, well, how could I have a guarantee obligation if there's no obligation of the underlying obligor? And the Court of Appeals in Fish said, well, you can, because that's what we think is the law on guarantee in New York. So Bank of New York Mellon, at least in the context of RMBS, went the other way to that. And so that is why we believe we had a reasonable excuse for not bringing these bankruptcy facts, especially the way the defendants framed the argument, where they wouldn't have made a lick of difference prior to the decision in Bank of New York Mellon.
But, for me, it was a strategic decision to rely on one argument that you thought was a winner. It turned out it wasn't, but I don't know why that gives you a chance to go back and make a secondary argument that you should have known to make at the time the original motion was made, and that the decision at the appellate division doesn't affect that argument, that second argument, really at all.
But that's basically imposing a standard where you're saying that if a defendant moves to dismiss on one ground and the law exists in New York at that time, the plaintiff at that point has to say to the motion court, hey, even though this won't make a bit of difference with respect to the argument the defendant is making, if the law happens to change on this issue, then you should also consider these facts. And there's just
Well,
too many.
I guess maybe the problem is that, well, you may have had a reasonable argument, you know, when Bank of New York came down. I'm not sure it really qualifies as a change in the law. You thought you had precedent in other circumstances that were analogous that would support your position. And I don't even take issue with that. But I don't know if that's enough to make this a change of law. But I understand your argument here, and let's hear from your adversary because you're way over your time.
Thank you, Your Honors. Seiji Newman from Davis and Gilbert for Defendant Natixis. And let me just pick up where Justice Gish, you left off. As to why plaintiff did not raise the issue of First NLC's bankruptcy in response to the underlying motion to dismiss, plaintiff insisted that the bankruptcy was simply, quote, not relevant or is inconsequential before the Bank of New York decision. But as you pointed out, Justice Gish, in its opposition to Natixis's motion to dismiss, plaintiff argued that Natixis's backstop obligation was triggered, and so the limitations period began to run upon First NLC's failure, the originator's failure, to repurchase within 60 days of certain repurchase notices or breach notices. And so plaintiff could have argued then, as again the court has alluded to, as it does now, that it was First NLC's supposed repudiation or rejection of the ARA, the Assignment Recognition Agreement, that in fact was what triggered Natixis's repurchase obligation. And in fact, the trial court itself addressed this issue head on and stated, quote, in responding to Natixis's challenge to the timeliness of the action, it was incumbent upon plaintiff to assert any basis it had for claiming that Natixis's obligation to backstop accrued at some earlier time. And that's in the record at 12. But beyond just the fact that plaintiff sat on its hands, and as again, Justice Gish, as you also alluded to, Bank of New York simply did not from one day to the next, quote, dramatically change the legal landscape, as plaintiff has described it. And it does not provide the reasonable justification for this motion to renew, which is necessary here. Justices Gish and Weber, as you may recall, having sat on the panel for the Bank of New York decision, that decision relied extensively on and really just built upon the Court of Appeals' decision in ACE, which had been rendered. Sorry, go ahead, Justice Gish.
Yeah, I'm agreeing with you.
Oh, and it had been rendered well before briefing even on the underlying motion to dismiss had even begun. And in fact, in Bank of New York, this court began the key passage that is the focus of plaintiff's appeal by stating, quote, in sum under ACE, and then it continued with its key ruling there. And that was at 151 83rd at 80. And the trial court, too, also understood the exact nature of Bank of New York and its decision. And the court explained that the decision, quote, represented a development of the law on the circumstances under which a repurchase notice could trigger a backstop obligation. The decision did not make an entirely different trigger suddenly relevant. And that's at page 11 of the record. And of course, separately, there is the fact that there was an 11-month period between when the Bank of New York decision was rendered and when the trial court rendered its decision on the underlying motion to dismiss. And so accepting for a moment that plaintiffs claim that, and he's repeated it here, that the Bank of New York decision really did fundamentally change the law, as they've also described it, there's simply no reasonable excuse for plaintiff's failure to request supplemental briefing on the significance of that decision, or even simply to bring the decision to the attention of the trial court during that 11-month period, which it is expressly allowed to do, Your Honors. And accordingly,
well, I don't know what difference it would have made, because on the issues that were before the court, Bank of New York was controlling, but it doesn't make a difference, I don't think, on the issues of the bankruptcy.
That's absolutely right, Your Honor. It doesn't make any difference. And that's because those new facts, supposedly new facts relating to the bankruptcy, simply don't change the result here. And just very quickly, I know counsel didn't address this, but just very quickly on those new facts. First, this is not an executory contract that could be rejected or repudiated by a debtor, as First NLC was. Second, even if it was somehow an executory contract, under the bankruptcy code, what occurred is a rejection, not a repudiation. And it is clear that rejections are deemed to occur as of the petition date, which is January 2008, outside the statute of limitations. And thirdly, even if it is an executory contract, and even if it is deemed to have been repudiated, this is not a valid breach notice. It didn't identify any allegedly defective loans, and it didn't provide the debtor, First NLC, with any opportunity to cure or repurchase those loans within a cure period. And in fact, if the rejection or repudiation of these ARAs, it doesn't equate to a breach notice any more than, frankly, First NLC's own filing for Chapter 11 in January of 2008, or the conversion of the Chapter 11 to a Chapter 7 liquidation, or the filing of the proofs of claim by the trustee for the underlying securitization itself, which occurred in April of 2008. All of those events occurred more than 6 years prior to the commencement of the action. And so these new facts, too, simply do not save plaintiff's claim here. Accordingly, the trial court correctly denied plaintiff's motion to renew. The trial court did not abuse its discretion, and this court should therefore affirm. Unless the court has any questions, we will rest on
Any
our.
questions, colleagues?
Thank you.
All right, Mr. Hampson, you have 2 minutes for rebuttal.
Thank you, Your Honor. So first of all, this was an executory contract. It had mutual obligations on behalf of both sides. Second of all,
Weren't they performed on the other side? Weren't they fully performed already? And
No.
does that affect whether it's an executory contract?
So it's whether there are mutual performance obligations, but no, they were unperformed. The First NLC would have had a repurchase obligation, which it rejected in bankruptcy, and the trustee itself had a notice obligation, which would have been something going forward. So there were mutual obligations. With respect to Mr. Newman's point about when the repudiation was deemed to occur, the law is crystal clear in the federal courts that when a contract is rejected and repudiated in a Chapter 7, the time of rejection is at the time that the contract is actually rejected. It's not a pre-petition claim, as he said. That law is in our brief. And the idea that this didn't somehow trigger Natixis' obligation just doesn't make sense. It was a repudiation by Natixis. By First NLC, excuse me. First NLC said, we are no longer going to abide by our obligations to repurchase. So that's what triggered Natixis' obligation under the backstop at that time. And we filed within 6 months of that time. If I just may wrap up by saying, you know, I understand there are some concerns about the way things transpired in this case, but what it comes down to is New York has a public policy about hearing cases heard on their merits. And here we have a several $100 million case about bad loans that were sold by this defendant into a trust.
We're certainly aware of the stakes in these cases. We've gotten a lot of them, and they are indeed tragic cases. So we know what's at stake. I don't dispute that with you. I don't think any of my colleagues would either.
And I wasn't meaning to suggest that you were, Your Honor. I was just trying to emphasize the importance of, you know, we should allow this case to go back down, and we should be able to determine whether this bankruptcy triggered the obligation of Natixis under the BNYM parameters, the paradigm of Bank of New York Mellon, because that's not what was argued below. And the defendants have a reaping a windfall of law that didn't exist when they made their motion to dismiss. And it all seems a little bit unfair to us. Thank you.
Okay, thank you. All right, at this time, the session, this concludes the oral arguments for today, and the court is adjourned. Thank you all.
Thank you, Your Honors.
Thank you.